Welcome to Justice for New York. I'm your host, Charles Collins. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. There are also family court petitions concerning the right to a jury trial, petitions to vacate support magistrate and judicial hearing officers' orders as they are issued in violation of the New York State Constitution, and there is also a demand for probation reports and psychological evaluations that the court orders, but the court orders that you can't read them or see them. That is a violation of your right to due process and equal protection of the law. They also order that the people preparing these reports do not have to testify and there is no accountability. This has to stop. Demand your reports so you can know what's being told to the court. And now for our presentation. Thank you. Okay, the next issue we're going to discuss is how the judges are fixing court cases. I'm going to give you three here. This is going back a few years ago when we had the number one deadbeat dad owes over $500,000 in child support. He was one where they brought him back to New York State on a felony complaint, and as soon as they brought him into the state, they transferred the proceeding and him to family court. They didn't prosecute him under the penal law. Now, you wonder why. Here's why. And I don't know what arguments his attorney made, but this is what I would have done. And I'm going by what was printed in the newspapers where I'm coming up with my figures. Just so everybody knows, these were in articles in the paper. They stated the father was earning $180,000 a year. We can assume on that type of income he's paying at least 35% in income taxes, possibly more. So you take out $63,000, which is $180,000 minus $63,000, gives him an income of $117,000. A lot of money, but is it? He was ordered to pay $9,000 per month for 3 children. That's $108,000 a year in child support. One of the children was about, I guess, ready to become emancipated. So they ordered that when the one child became emancipated, he would only have to pay $8,000 a month, which is $96,000 a year for 2 children. I wonder who that money was going to, the children or the mother. $117,000 minus $108,000 in child support leaves him $9,000 a year to live on. That's below the poverty level. And he's making $180,000, but he only gets to keep $9,000. That's about 5% of his income. Now, $108,000 divided by 3 kids is $36,000. So each one of his children get to live on $36,000 a year, while Dad gets to live on $9,000 a year. Now, he's now reduced to 2 children, $117,000 minus $96,000. He got a boost. He's out of the poverty level. He's now at $21,000 a year. But each of his other 2 children got a boost because $96,000 divided by 2 is $48,000 a year. So each one of the kids gets to live on $48,000 a year, while he gets to live on $21,000. What is wrong with this picture? Nichols was prosecuted under Family Court Act and not the penal law, even though he was charged under the penal law in order to bring him back to New York. Based upon the articles I've read, the child support order probably didn't comply with the law. These are the facts what was in the paper. It didn't comply with the law. This is supposed to be child support. It is not child support. It is mama support. Once the mother gets the money, she can spend anything she wants. She's getting this money. Where's the money? Are the kids? She's spending all that money on each of the kids? I'll guarantee you, she doesn't spend $36,000 on each child or $48,000 on each child. That supports her and the kids, and she gets to spend the majority of it on herself. Family Court states that parents are chargeable with the support of the child. Then there should be a court order requiring both parents to pay. Why isn't the mother paying? She gets to keep her entire income. She doesn't have to spend it on the child like the person paying. There is no accountability to where the child support goes. Any child support over $150 per week should have to be accounted for. And the custodial parent needs to document the money spent, their share on the child. Both parents should be required to pay it. Give you another example. A few years ago, I had a father, both the mother and the father earned about $80,000 a year. The court made an order that both were to pay 50% of the children's college education. The two kids were in college. The order also stated that neither parent was to have the children take out loans for school, that the parents were to split it. Well, the father found out the mother, to cover her share, had the children take out student loans in violation of the court order. We did a motion to the court to have her pay her share and get rid of the student loans. The court's response was the father did not have standing to have her pay for it and dismissed his petition. In other words, and the court then said, if the children want their money, they can take their mother to court. What child wants to take their mother to court? I can tell you, if been reversed, where the father didn't have the children take out loans, the mother would have been in court and the judge would have been more than happy to make sure that the father paid his share and got rid of those student loans. This is what happens. Now, this was a person that was before one of my buddies, our Judge Kramer in Schenectady. And this is what Judge Kramer did. The father had a job, I think it was with Time Warner. He was making $11 an hour, but his paycheck was for $430. He had federal taxes of $38, Social Security at $25, Medicare, $12 for New York tax, $24 for medical, 50 cents to United Way. He was in a union. He had 2 union dues he had to pay, $430 and $450, which brought his net pay down to $312. What does Judge Kramer do? And what he did was, he was very smooth in the way he screwed the guy over, because you needed the findings of fact and the judgment of divorce. There are 4 issues involved. 1, the father's gross income, maintenance, child support, and daycare are the 4 items. In one document, he dealt with the gross, the maintenance, and the child support, but did not address daycare. In the other document, he addressed the maintenance, the child support, and the daycare, but not the gross, saying that he was capable of paying. So from the $312 net pay, you minus $75 for maintenance, $82 for child support, and then $144 for daycare, leaves him $11.95 a week to live on. I'm sure Judge Kramer spends more than that on his lunch every day. Now, not only does, well, I shouldn't say that. The $11.95, he was also ordered to continue coverage of health insurance for the children and pay 64% of any uncovered medical and dental expenses. And what Kramer did, which was even more egregious, was he ordered the SCU to take $301 out of his paycheck each week, which is the $75, the $82, and the $144. He ordered them to take the $301 from the $312, which left him $11.95. Now, we go to the appellate court. We filed an appeal. The father wins the appeal. But the appellate court couldn't resist screwing him one more time. They overturned it, said it didn't comply with the law. What happened was, when they started taking the $301 out of his paycheck and leaving him with $11.95, he didn't have gas to put in his car. Guess what? He lost his job. Now, he ended up living out of his car for a week or two, and then ended up moving in with into his mother's house. He went to her and, come on in, and he was living with his mother. Here's what, now, he wouldn't have had to move in with his mother if Judge Kramer had followed the law. He wouldn't have lost his job if Judge Kramer had followed the law. The appellate court sent the matter back to Kramer to redetermine. I'll tell you, the second time Kramer also screwed him again. But he got injured and he ended up on SSI. So that sort of ended the second proceeding and it got reduced. But this is what the appellate court did. We observe, however, that the defendant testified that he has been living with his parent essentially rent-free. Well, where else is he going to live? Because he has no money. Income for purposes of calculating child support includes money, goods, or services provided by relatives or friends. And cites it a minute. Defendant's lodging is thus a service provided by his parents. Moreover, there was testimony at trial suggesting that, that plaintiff may be receiving service from friends or relatives. Accordingly, we remit this matter for recalculation of the party's income and respective child support obligation, including a consideration of those resources available to the plaintiff and the defendant beyond their salaries as the Supreme Court, in its discretion, determines appropriate. In other words, they're telling them because he's getting lodging from his parents rent-free, that is a benefit to him, the court has to add that to his income. In other words, he probably would have been better off staying out on the street because then they wouldn't have add income to it. This is what they're doing. In my case, when I first started off in family court, I was ordered, I had a gross pay of $400 a week, federal of $64, Social Security, New York State tax. I came home with $284 a week. After I got done with Judge James, he sent it over illegally to Hearing Examiner Warner in Schenectady. And James first ordered me to cover it. I was to pay a mortgage of $967. I was to pay utilities of $150. So my total year would be $13,404 on $284. Not only that, I was also ordered to pay $6 a week in child support for another $3,000. So I'm up to $16,284. I'm below $15,000. I have no income. How do you pay this on that income? Plus the $13,000 plus the $3,400 equals $16,836. Support obligation, I'm bringing home $14,773. Then they boosted this to continue this, but then they boosted it to, I was to pay $120 a week in child support. Reissued the order. I was required to provide health insurance, 800 past due medical bills, 71% of medical bills, and $940 in an orthodontic bill. Someone explain to me, when you're bringing home $14,773, how you can pay all this stuff. I would love to see the math behind it. I'm not the only one they do this to. They've done it to a lot of people because I've seen it. March 5th, quotes from the separation agreement. Warner has admitted that he knew about the separation agreement. Family court has no jurisdiction over the separation agreement. He had no authority to do what he was doing. Warner, the principal interest and taxes on this property is $960 per month. Respondent is under existing order of Judge James to continue to provide this or a substantially similar residence for the church. He knows I can't afford this at this point, and then he's going to tack on more on top of it? While admittedly such payment cannot be ignored by the court in fixing appropriate supporter, it must be also recognized as building equity in the real estate, which will ultimately ensure to his benefit. I would love to see a piece of property that you can buy, that you pay $967 a month, that at the end you're going to get back your money on the mortgage. There isn't a house that I know of that increases in value at the rate of $967 a month. And if you go look at the last few years, how many homes out there, thanks to the Democrats, are underwater? A lot of them. So this is what they're doing. You know, how many people owe more on their houses? They keep bringing this back, but they don't address the issue. He addresses it, but if you notice one thing, he never stated in the order what my income was. He just decided what I was going to pay. Income is not an issue. Several other courts, which I'll be addressing a little bit later, also held that to be my income. But yet, I was still required to pay all this stuff. And you wonder why people are frustrated? Peter called me up from up north, and he was getting hammered by the family court and the Supreme Court. So he came down, I started talking to him about his child support. It wasn't adding up. He was telling me how he was supposed to pay $128 a week in child support. And he's got 4 kids and all this. And one of the kids live with him and everything else. I go, wait a second. Why aren't you collecting support for the child living with you? What do you mean? I can get support for the child residing with me? Now the mother earns about $50,000 a year. He makes $25,000. Technically there should be no support, because one is based on 17% of $25,000, 29% of his income based on the 3 children. One of the arguments, the stipulation stated, with respect to child support, Your Honor, child support will be established at $128.82 per week. This is based on the defendant's current income of $25,000 per year, in accordance with the provisions of the Child Support Standards Act. The parties acknowledge that the child support has been computed in accordance with the Standards Act, which presumptively results in the correct amount of child support. Both parties have been apprised by their attorneys of the child support guideline. What a bunch of crap. The party's judgment and stipulation of the parties did not comply with the law. There was no mention of the mother paying the father child support for the one child. We documented from October 31st, 91 to when he came to see me in 99 was a total of 395 weeks. 52 times 7, there's 52 weeks, times 7 equals the 364. This was the year, and then the added on where we came up with the 395. 395 weeks at 128 weeks is $50,560 total to support to have been paid. Now he couldn't always make the payments. Notice, there is no figure for the mother to pay child support for the son residing with the father. It was documented that the mother earns $50,000 per year. Based on $50,000 a year minus the FICA and Medicare, brings her income down to $46,175 times 17% times divided by which would be $150.96 per week. She will have paid him, for a total of $59,309. So they're having him pay, but she's not paying anything. He just got screwed out of $8,749 plus the $50,000 that he paid that he shouldn't have paid because she owed him that. So totally, he's out about 59. She was more, so you can add that to the 59,000. In 97, we commenced an action to get it repealed. Family court entered a violation support order, dismissed his cross petition, holding that family court had no authority to overturn an order made in Supreme Court. They are absolutely right. But the family court, by separate petition, respondent also sought a family court order directing petitioner to pay him child support for the child residing with him. They're saying we can't overturn it. Well, if they can't modify it, they can't enforce it. They have no authority to. If the family court had no jurisdiction to modify the Supreme Court order as stated by Spain, then how does the family court have the authority to enforce the Supreme Court order? Judge Spain. Respondent moved in Supreme Court, Clinton County, for an order vacating the child support provisions of the 92 judgment of divorce and awarding him child support for the child who resides with him. Supreme Court agreed with respondent, concluding that the parties' 92 stipulation did not comport with the law. Where, as here, Supreme Court does not expressly retain jurisdiction to enforce or modify judgments of divorce, family court may entertain an application. Absolutely wrong. The Constitution says that it has to be referred, not retained by the Supreme Court. In other words, they don't want to address the Supreme Court. I got another ruling here by another, who is this one? By Carpinello. Does the same thing. Respondent's argument that family court lacked jurisdiction to entertain this proceeding is without merit. Whereas here there is a Supreme Court judgment providing for child support, and the Supreme Court has not retained exclusive jurisdiction to enforce or modify. It's wrong. We made the argument. The Constitution says it has to be referred. They're using these unconstitutional state statutes that the courts are refusing to address to deprive people of their rights to due process and strip them of money that they're entitled to with these bogus court orders. It doesn't have to be retained. And don't tell me that Judge Spain doesn't know it. It was in there. Judge Spain hasn't found an order that he hasn't liked to screw somebody over in. Believe me. Although it was in family court's discretion to treat respondent's child support petition as an application to modify the child provisions of the judgment or respondent never alleged any significant change in circumstances which would have provided family court pay. Yes, he did. The court order doesn't comply with the law. The court order not only doesn't comply, but he's entitled to child support that he was never informed of under the law. He doesn't address anything. Defendant argued to pay plaintiff based on his current income. Both parties were represented by counsel. Again, counsel selling out the father. Tell me that the judge, her attorney, and his attorney don't understand the law and that he was entitled to child support. But all three of them kept their mouths shut. They defrauded him of $50,000. Under New York state law, these orders are felonies, but this is also grand larceny. And they are all participants in it. $50,000 is a lot of money to get screwed out of. But the reason is, they won't say it in here, they're not going to turn around and tell the mother, oh, by the way, we made a mistake, so you're going to have to repay him. They knew from the beginning. They just figured we're going to get away with this because we always get away with it. The Supreme Court agreed that the parties always failed to comport with the CSA. Defendant from plaintiff, the application modified for several reasons, including that the judgment would negatively affect the accumulated child support arrears owed by the defendant. Well, it depends on which side. He owes arrears. He wouldn't owe the arrears if the order complied with the law. Those arrears should have been vacated. Where is it here? There's one. They state in here that there is no right to restitution in New York State if you've overpaid. If you've underpaid, you're entitled to have the money paid. But if you've overpaid, you're not entitled to a credit against your future child support obligations, which is a denial of due process and equal protection of the law. And as the appellate court in the Third Department held, well, the mother has a common need for child support to support the children. Most of the child support doesn't even go to the children in a lot of cases. But you should be entitled to a refund. That's a denial. They won't address the issue. I've raised it in several court in appellate reviews, and including mine, where they made that wonderful statement. Now, in '99, he was also brought into court. Now, the Supreme Court has already ruled this order doesn't comply. The family court order didn't comply with the law. If a respondent is brought before the court for a failure to obey any lawful order of support, then we went into all the punishments where he's entitled to a jury trial. Authorizes family court to act where there is a willful violation of any lawful order. Well, if the Supreme Court judge has already ruled that the order doesn't comply with the law, how can he be in violation of the order? And if the family court had one, that also violated the statute. In order for the court must be obeyed, no matter how erroneous it may be, so long as the court is possessed of jurisdiction and its order is not void on its face. These orders are void on their face. The parties which incorporate but did not merge a stipulation. That's stipulation. Family court has no authority to enforce or modify stipulations. You know, this is why there needs to be jury trials, because of what these judges are doing. And this is just a few examples. There's a lot of these. And they even agree. They finally agreed. Initially, they first determined that plaintiff owes $35.17 per week. Only going back to the date he filed the petition, not back to 1992. And the 35 was deducting what he should pay from what she should have paid him. So they did agree on that. Initially, we conclude that the Supreme Court properly determined in the 1997 order that the 1992 stipulation failed to comport with the CSSA because it did not specify the amount that such basic child support obligation from plaintiff to defendant would have been, and the reason or reasons that such agreement or stipulation did not provide for that amount. Here's the kicker, what I was talking about a minute ago. Courts are generally prohibited from vacating accrued child support arrears unless strict application of the statute undermines the legislative intent and causes a grievous injustice. What is more grievous than having a father overpay by $50,000? Not only that, he was having trouble seeing his kids. And right after this, because he didn't get the arrears vacated, that he should never vote, he went to jail. Now, about 2 years after that, he showed up and he brought his oldest daughter with me. His oldest daughter was in school over in Boston, working 3 part-time jobs to help her go through college. She goes, "My father always tries to help me, but I know his financial condition and that he really can't afford to, but at least he attempts." She wanted to stop the child support for her going to the mother because the mother refused to do anything to help the child with her college expenses. Even though she was making over $50,000 a year, she would not help and collecting child support, she would not help this child with her college. But Daddy, who's willing to stand up, gets screwed for doing the right thing. And then I always love this at the end. When the court doesn't want to address everything, you'll see it in lots of court orders. They go, "We have considered defendants' remaining contentions and we find them to be without merit." In other words, we're not addressing him because he's probably right. So we're just going to dismiss it. There's also this. We also, you have that new ruling, Swift versus Usenza. That's on point. That's what it should have been ordered back here. Now, a good friend of mine, he ended up in court several times with his ex-wife. And what happened in his case, when they were married, she had free health insurance with the children, with him and the child. Afterwards, she decided, "I want him to pay for health insurance." So she files a petition with the court to be paid for child support, or for her costs for the health insurance. And he's going, she doesn't have any costs, it was covered by her employer. So we stated, we want a copy of her pay stubs to see what's paying, and then we also wanted a copy, the original copy of what it is for a single person and what it is for a single person with one other, or the family plan. Well, we got the thing on the single person, the family plan, but she refused to turn over her pay stubs. She now claims, well, it's not deducted from my paycheck each week. I pay him the first of the month. Okay. We want to see her paycheck is direct deposit. So we want to see her checkbook. The check she writes to see where the money is taken out to pay for the health insurance each month. You can't have that. We go into court. The judge says, "You're not entitled to it." What do you mean you're not entitled to it? The judge denied it. He wasn't allowed to get any information or copies. We got copies of the receipts, which was funny because all the copies he took a page. It was like they were all written at one time. The writing changed a little bit, but the writing was there was 3 receipts to a page, or 4, and there's 1, 2, 3, 4. You flip the page. Now, to make it even more interesting, every one was dated the 1st of the month. January 1st. I don't think they were open, but it was dated January 1. March, April, May, all dated the 1st of the month. Well, someday, I don't think they were open on Sundays. So, how could he write a receipt on that? So we got the receipt, but we still don't have the any proof she paid it, except for these receipts. They get into court. The boss is put on the stand. He testifies, well, she doesn't always pay on the 1st when confronted with this. Then it was, well, some months she pays a couple of times during the month. Well, then why did you write out a receipt on the 1st if she pays 2 or 3 times during the month? Absolutely nothing made any sense. The court then ordered him to pay the child's health insurance, which was free to her because there was no proof that it was given. Our illustrious appellate court, in essence, the claims that the respondent does not actually pay the child's health insurance, rather, according to the petitioner, is provided at no cost to the employer. Following a trial, the support magistrate determined that respondent does pay for the child's health insurance and thus dismissed the petition. Family court thereafter dismissed written objections prompting this appeal. We affirm. At trial, respondent and her employer unequivocally testified that although respondent receives individual health insurance coverage as a benefit of employment, she is obligated to pay the additional cost for the family court. There was not one canceled check or anything coming out of her checking account, nor was there anything deducted in her paycheck showing this. It was them on the stand saying she pays it with no proof, and he's being denied his right to get proof that she isn't paying it. Both unequivocally testify that respondent pays cash for this additional expense on a monthly basis. If she paid cash, she would have had to take the cash out of her checking account to get the cash to pay. Why would she pay cash? Well, the reason being is there's no record, but also she's not paying it. Written receipts were admitted into evidence. Yes, all dated the 1st of the month and all in chronological order. We wanted to see the entire receipt book, not the pages it was written on. The reason being is there were probably others, but it would have shown that all the receipts were written at the same time. Because if you looked at the dates on the prior pages, he was subpoenaed to bring that book to court. Guess what? The doctor didn't bring that book to court. Finding that the respondent pays for health insurance, petitioner remains obligated to reimburse for his 40% share of this expense and for modification. He's not entitled to anything. Shouldn't have had to pay anything. There was no proof. Again, case fixing. General Snyderman, Senator Schumer, and Chief Judge DeFore. Which is it? Deadbeat dad or beaten dead dad? These fathers are beaten dead by the system. And this is just a small sample that I had. There are a lot of them out there. I've worked with a lot of fathers. And the court does nothing. The court is there to screw them out as much money as they possibly can. Look at the father, deadbeat, $500,000 in debt. Yet, when you take out his taxes and you figure it all out, based upon what was stated in the newspapers, the children, he gets $9,000 a year to live on, but his children get $36,000. And then, when one becomes emancipated, He gets $9,000 or $21,000. They get $48,000 each to live on. I'll guarantee you that money is not being spent on those children and is not being put away for the children. That money is being spent by the mother on herself. What about the father? He's left with $10 a week to live on by Judge Kramer. Kramer knew that order didn't comply with the law. But who cares? And then he ends up losing his job because how do you live on $10 a week? He lives out of his car, finally moves in with his parents, and then the court turns around and says, that's a gift to you. That's a benefit that you're living with your parents for free. A benefit. If the judge had followed the law, he wouldn't have lost his job. He wouldn't have had to move in with his parents. He might have been able to afford his own place. Screw him over. And the appellate court screwing him over by saying that's a benefit and they have to add that to his income. In my case, I was ordered to pay more than, for over 12 years, I was ordered to pay more than my income to child support. You tried taking, I'd love to see you guys have your entire income taken away from you and given to somebody else. I'm sure you would be in the same boat I am, yelling and screaming. And then you got Peter. He sits there. He didn't even know they didn't even tell him he was entitled to child support for the son living with him. She should have been paying him $35 a week as determined at the end. They screwed him out of over almost $60,000. The $50,000 they made him pay and the $9,000 he should have received from the wife. Or 59, but minus the 50, it still comes out $59,000. His attorney, the judge, and her attorney defrauded him of. And don't tell me these two attorneys and judge don't know the law. They knew exactly what they were doing. They belong in jail. But no, the appellate court covers up for them and lies. And you're not entitled to restitution when the order doesn't comply with the law? They don't want the mother to have to repay the money. They should have made sure the order complied with the law in the beginning. Then they put him in jail for violating a court order that the Supreme Court has already determined doesn't comply with the law. Well, if it doesn't comply, how is it a lawful order? It's not. The judge that sent him to jail should be in jail himself. I ended up learning the law because of the corruption and being ordered to pay more than my income. You think it's all a joke. The thousands of families in this state that are being destroyed because of these so-called closed court, family court proceedings. The denial of the right to a jury trial. If all of us had jury trials, I guarantee you, all of us would have been found not guilty. But then again, they'd probably make sure the evidence didn't get in, showing that the order doesn't comply with the law. In other words, the jury has to accept us stating that the order complies because we wrote it so we know what we're doing. Yeah, they know what they're doing. They're knowing exactly how to defraud people out of thousands of dollars. Why aren't these judges and attorneys being prosecuted? Issuing a false certificate. These court orders these judges are issuing are illegal, and they are meant to defraud, deceive, and injure people paying child support. Something needs to be done, and it needs to be done now. Probably starting with one of the four of you needs to shut down the family court in this state and get rid of the hearing examiners or support magistrates. Open the court. If the court is required to be open, every judge in this state who's had a closed court proceeding needs to be removed from the bench. Unless they can produce a finding stating why they were closing the court and everything. And it needs to be in the file. and then double check with the litigants, because I'm sure they'll be pumping them out like crazy. But they need, these judges that have closed courtrooms need to be removed and prosecuted for official misconduct. That's where it's got to start. Because until something is done, it's going to continue. Do something now. Stop all the talk. You all love to talk. I don't care where the corruption is. I don't care what party it is. I'm going to defend the people's rights. Bullcrap. Let's see you all do something. That it won't happen, because you're all cowards. And you will not stand up for people's rights in this state.